Few modern criminal cases have generated as much speculation, outrage, and misinformation as the case of Jeffrey Epstein. In recent years, phrases like the Epstein files, the Epstein list, or DOJ documents have spread rapidly online, often accompanied by claims that the government has secretly confirmed the names of powerful celebrities involved in Epstein's crimes. The reality is far more complex and far less sensational than many viral posts suggest. Understanding what the Epstein files actually are, what has and has not been released, and how names end up in legal documents is essential if the public wants truth rather than rumors. This distinction matters not just for accuracy, but for fairness, credibility, and the integrity of journalism itself. There is no single official document called the Epstein files. The term is a catch-all phrase used online to describe a collection of unrelated materials that emerged over many years, including court filings from civil lawsuits, deposition transcripts, exhibits and emails submitted as evidence, flight logs and contact lists, previously sealed records later unsealed by court order. Most recently, public attention has focused on documents unsealed in Giuffre versus Maxwell, a civil defamation case involving Virginia Giuffre and Ghislaine Maxwell. These records were not new investigations or new findings. They were old materials made public after years of legal proceedings. Crucially, these documents were not released by the Department of Justice as a criminal disclosure, nor were they presented as verified findings of wrongdoing. One of the most common claims online is that the DOJ released a list of celebrities connected to Epstein. That claim is false. The Department of Justice has never released a public list of Epstein associates, celebrities, or alleged participants in crimes. In fact, DOJ policy and U.S. law make this extremely unlikely. Here's why. Grand jury materials are secret by law. Uncharged individuals cannot be publicly accused by prosecutors. Victim privacy protections limit disclosures. Ongoing investigative records are not made public. What has been released came through courts, not prosecutors. Judges may order documents unsealed in civil cases if they determine public interest outweighs privacy concerns. Even then, unsealing does not mean endorsement, verification, or accusation. In short, if you see claims that the DOJ confirmed names, that information is incorrect. This is the most misunderstood part of the entire controversy. A name appearing in a court document does not mean the person committed a crime, the person was accused by prosecutors, the person was investigated, the person had contact with Epstein. Names can appear for many reasons, including being mentioned in testimony or hearsay, being referenced in emails or schedules, being named by someone else without corroboration, being part of social or professional circles, being included as contextual background. Courts do not fact-check every name that appears in filings or depositions. These documents often contain raw, unverified claims that are later tested or never tested at trial. This is why legal experts repeatedly warn against treating court exhibits as proof. This distinction is everything. Being named means someone mentioned a person in a document. The name appeared in an email, log, or transcript. There may be no claim of wrongdoing at all. Being accused means a formal allegation is made, the claim is specific and attributable. It may still be unproven, but it is explicit. Being charged or convicted means prosecutors brought a case, evidence met legal thresholds, due process occurred. Most high-profile names circulating online fall into the first category only. In many cases, the documents explicitly state there is no allegation of misconduct tied to those individuals. Collapsing these categories into one is misleading and potentially defamatory. The Epstein case exists at the intersection of legitimate public anger and viral internet dynamics. That combination is combustible. Several factors fuel misinformation. ambiguous language. Headlines often say named in files without explaining what that means. Screenshots without context. Single pages are shared without surrounding testimony or disclaimers. Algorithm incentives. Platforms reward outrage, not nuance. Distrust of institutions. Many people assume secrecy equals guilt. Bad actors. Some deliberately imply wrongdoing for clicks or political attacks. Once a claim spreads, corrections rarely travel as far. Over time, speculation hardens into assumed fact, even when no evidence supports it. Jeffrey Epstein committed real crimes. Real victims were harmed. That alone demands seriousness and care. When reporting becomes reckless, several harms occur. Innocent people may be falsely implicated. Actual victims' stories are overshadowed. Public trust erodes further. Future investigations become politicized. Responsible reporting does not protect the powerful, it protects the truth. It is possible and necessary to demand accountability, criticize failures by institutions, investigate wrongdoing aggressively, while still respecting facts, due process, and evidence. Despite years of reporting, many questions remain unanswered. Who else enabled Epstein financially or logistically? Why were prior investigations mishandled? How did Epstein maintain influence for so long? What institutional failures allowed abuse to continue? These are valid questions. They deserve serious investigation, not viral guesswork. The Epstein files are not a smoking gun list released by the DOJ. They are a collection of legal documents, many unverified, often misunderstood, and frequently misrepresented online. Being named is not the same as being accused. Being accused is not the same as being charged. And being charged is not the same as being convicted. If the public wants accountability, truth matters more than rumors, precision matters more than outrage, and responsible reporting matters more than clicks. That's not protecting power, that's protecting reality.